everyone, and welcome to this bite-sized session. My name's Alicia Mahmood. I'm an associate at TLT, and in this session, I'm going to be talking you through the changes which the new Procurement Act has introduced in respect of exclusion grounds. In terms of a bit of background about me, you can see that on the slide here, but I'm experienced in advising public sector bodies in relation to public procurement law. I'm going to be talking you through a couple of questions in relation to exclusion grounds today. So in terms of what the topics are that we're going to be covering, the session is going to focus on 6 key topics that we've listed here. So these are what are the aims of the exclusion regime, what are the changes to the exclusion grounds, what is the impact of being an excluded or an excludable supplier, can I be excluded by the actions of another entity? When should exclusions be assessed? And also, how can I challenge inclusion onto the debarment list? In summary, the regime is there to protect public funds, to protect public confidence in the honesty and integrity of suppliers, and to ensure that contracts are delivered and that suppliers are reliable, and also to protect the public, the environment, national security interests, and the rights of employees. So in terms of the grounds under which you can be excluded, I've outlined them here. In summary, the mandatory grounds are those more serious scenarios where an authority has no discretion as to whether they exclude you if these apply. They cover the most serious and high-risk scenarios. In terms of some of the key changes from the Procurement Act, inclusion of new grounds have seen that we have a mandatory ground of theft, modern slavery and human trafficking offences, corporate manslaughter and competition law infringement. The other type of exclusion ground is a discretionary exclusion ground. And so for these, authorities do have a discretion as to whether they exclude if these apply. And these are in areas such as poor performance, labour misconduct, national security threats, and essentially they're aimed at tackling underperforming suppliers or suppliers who pose unacceptable risk. A key change in the area of discretionary grounds is in relation to poor performance. So previously, authorities would be able to exclude you if you poorly performed, if there was a serious sanction, such as having a contract terminated or damages awarded, whereas the threshold is now lower, and authorities can therefore exclude where suppliers are not performing to the authority's satisfaction, where they've been given a proper opportunity to improve their performance and they've failed to do so. So a key change in terms of the discretionary grounds is for the ground of poor performance. It's also worth noting that the time limit for consideration of the relevant events which make up the ground has been extended for discretionary exclusion grounds to 5 years, which matches the period for the mandatory exclusion grounds. Moving on then to the potential impact of being an excluded or an excludable supplier. As you can see on the slide, an excluded supplier must be excluded from a procurement process. So if those circumstances apply to you, an authority won't have any discretion as to whether to exclude you. An excludable supplier may be excluded from a procurement process, and the authority has got some discretion here, including reviewing any self-cleaning measures that you've undertaken. And in terms of what makes up an excluded or an excludable supplier, in summary, this is where either a mandatory or a discretionary ground applies and the authority considers that the circumstances giving rise to the ground are continuing or likely to occur again. That's what makes you an excluded or an excludable supplier. It's also worth noting that you can be considered an excluded or an excludable supplier if you are placed on the debarment list by virtue of a ministerial decision, which we will talk about later on in this session. It's also worth noting as well that there are some exceptions where authorities can enter into contracts with suppliers who are excluded suppliers. These are a number of different situations, but for our purposes, I just wanted to focus on the circumstances where an authority can award a contract by virtue of a direct award to an excluded supplier, where the procurement is essential for the construction or maintenance of critical national infrastructure. This is because this constitutes an overriding public interest. And so authorities are able to award a contract to an excluded supplier by virtue of a direct award, where there is an overriding public interest. And one of these limbs is the construction or maintenance of critical national infrastructure, amongst other elements. Moving on now to the question of, can I be excluded by the actions of another entity? In summary, yes, you can be excluded by the actions of another entity. So where a subcontractor or an associated person, so this could be a key subcontractor, and means somebody who you will be relying upon to deliver the contract, or a connected person, so this could be a subsidiary of the company, where these are excluded or excludable suppliers. The supplier can also be excluded where they are using any of these. However, it should be noted that for subcontractors and associated persons, you should be given the opportunity to, and a reasonable opportunity to, replace them before being excluded. So in summary, whilst you can be excluded by the actions of others, in some scenarios, you should be given a reasonable opportunity to replace them before that exclusion happens. It's also worth noting as well that authorities will have implied termination rights, which apply in circumstances where a subcontractor or an associated person is an excluded or excludable supplier. So as well as exclusion, your contract could be terminated by virtue of a subcontractor or associated person becoming an excluded or excludable supplier. As this is implied, it doesn't need to be written into the contract. So even if you haven't got this in the termination rights that you've agreed by virtue of your contract, it is an implied termination right, so will still apply. It's also worth noting that by virtue of the Procurement Act, contracting authorities going through the competitive tendering procedure are obliged to request information about whether suppliers intend to subcontract the performance of the contract, and then to determine whether the subcontractor is on the new debarment list or whether they are an excluded or excludable supplier. Additionally, it's worth noting as well that providing a lack of information about a subcontractor may lead you to being excluded from the tender process as well. So it's really important that you are aware of any circumstances which may affect your subcontractors or associated or connected persons, and also that you're able to provide sufficient information to the authority where they request this. Moving on to our next topic, which is, at what point during the contract life cycle will these be tested? I think it's worth having a general overview of some of the key areas and points at which exclusion may be assessed by an authority. So essentially, exclusion is the gateway that you need to get through in order to, in the case of an open procedure, have your tender assessed. In the case of a competitive flexible procedure, for you to be able to participate or progress in the procurement or have your tender assessed. And in the case of a direct award, be awarded a contract by the authority. So authorities will be looking at exclusions at various different points during this process. And it's going to be really important if and because your circumstances could change at any point, if they do change, to let the contracting authority know as early as you can, as it's going to be more difficult for them to navigate the later on in the process that they are informed. So our advice would be to be really upfront and tell the authority as early as you can if you suspect any of the exclusion grounds could apply. This is because, of course, your circumstances could change, and also because contracting authorities are going to be testing out and should be thinking about exclusion grounds at the different stages and processes of the procurement procedure. And also, as you can see here, in relation to contract management as well. So it may be that throughout the life of the contract, the authorities are also checking whether exclusion grounds apply. And so it'd be really useful if you are also being kind of mindful of any change in circumstances, including in relation to any subcontractors or associated or connected persons, given the implications of the implied termination right, which we discussed earlier. Moving on now to the next topic, which is the question of what happens if you meet the mandatory or discretionary exclusion grounds after entering into your contract. As we've discussed, an authority can terminate an existing contract where a supplier has, since the award of the contract, become an excluded or excludable supplier. And that includes by reference to an associated person or subcontractor. So this is a scenario where you have entered into the contract with the authority, and as we've mentioned, circumstances can change. So if it transpires that you are now an excluded or an excludable supplier, or that your subcontractor or an associated person is, this means that the authority can terminate this contract. It's really important to know that this is a can rather than a must or will. So don't automatically assume that they will terminate the contract, but in terms of making sure that the situation is handled well by both parties, it's going to be really important to, as we've said, flag really early on, as early as you can, where you think the circumstances may have changed for you, as this may affect the authority's decision making in this area. If they've been given with sufficient notice, it may become easier for them to kind of find a solution that suits both parties. And as we've said here, it's really important to engage in constructive dialogue with the authority, as this is going to be the point at which perhaps the parties can decide a solution to help them move forward. And in terms of a blueprint for you when you are considering approaching an authority, if this situation is to transpire, a tip could be to point to the government guidance which applies to authorities, and use some of the elements which they are required to consider as the basis for making your argument as to why the contract shouldn't be terminated. So there are a number of factors that contracting authorities are required to consider by virtue of government guidance where this situation takes place and when they're considering whether to terminate the contract. And these factors are things like where the time elapsed on the contract or the time remaining, the nature and relevance of the misconduct to the specific contract, the impact of termination on public service, and the cost of termination and reprocurement. So these are all things that the authority is going to have to consider when reaching its decision on this. So it's a useful tip to, perhaps when approaching the authority, to be making a compelling argument using some of these factors and their existence when you are having this constructive dialogue with the authority and trying to find a solution that suits both parties. Moving on then to the next and final topic in this bite-sized session. So this is a really important question, I imagine, for a lot of suppliers. So what happens if you disagree with being placed onto the debarment list? So it's worth noting here that the debarment list is a new feature which has come into place as a result of the Procurement Act, and it's a centralised list which will contain excluded and excludable suppliers. And essentially, where a contracting authority excludes a supplier, it must notify the Cabinet Office that it has excluded them. And then it may be that a ministerial decision is made to add the supplier onto the debarment list. So it's worth noting that the kind of final aspect in terms of role for the authority is this referral, this notification to the minister. Once they've done this, it's the ministerial decision which will place the supplier onto the debarment list. The authority's role is kind of finished in that aspect once they have notified the minister. The minister will then investigate, and if they make the decision to place you onto the debarment list, any challenges to that decision should be directed to the minister and not the contracting authority. As I've said, it's the minister who will be making that decision. So in terms of timescales and factors to take into account where challenging this ministerial decision, it's important to note that suppliers will have 8 working days, which is being called the debarment standstill period, after notification of the ministerial decision to add them to the debarment list to apply for a temporary suspension. So you'd have 8 working days to apply for this temporary suspension where you've been notified. If your application is successful, then your name can't be added to the list until either 30 days have passed since you knew or should have known of the decision and you've not commenced your appeal, or that the appeal has been disposed of. So this could be it's been resolved or withdrawn. So it's really important to note timescales here. So 8 working days for the debarment standstill period, and then you must commence an appeal within 30 days from knowing or from when you should have known of the minister's decision. And it's really important to note here, as I've said, it's 30 days from when you know, or it can be considered to be that the time starts running from when you should have known of the minister's decision. And then in terms of the next step, this would be the court's decision. So the court will make the decision as to whether the appeal is successful or not. And it's worth bearing in mind when making any appeal here that it's quite a limited right of appeal that you would have. So the right of appeal is where the minister has made a material mistake of law, which is quite specific and quite limited. So it's going to be really important here to make sure that when making this appeal that you bear in mind the right which you have. This concludes my bite-sized session today. Thank you so much for listening in. If you have any questions, please do not hesitate to contact myself or any of my esteemed colleagues whose details you can see on the slide. And finally, just a quick reminder about our Procuring 360 initiative. This is TLT's support package for contracting authorities and public sector suppliers to help you to get ready for the new Procurement Act. We are able to offer a wide range of support, not just legal, but also technical, consultancy, and more practical support. So please do check out our website or contact a member of the team if you require any further support in relation to getting ready for the implementation of the new Act. And again, thank you for listening in.